Honourable Acting Attorney General.
Madam Speaker, I'd like to first and foremost thank all members who have spoken. I have listened very carefully to all the speeches and more so to that of the intervention of the Honourable Prime Minister just before me. I'd like to also thank right away, not at the end of my intervention, the officers of the Office of the Attorney General himself, who has put in a lot of effort in the work that he has produced. We are all very thankful to him, and I wish him a quick recovery. However, I'd like to add, I don't think I had to, but then I think sometimes it is necessary to underline important events. I mean, when I base myself on the intervention of the Honourable Leader of the Opposition and Honourable Adrien Duval, it's necessary for me to refer to the arbitral award, the final award in Singapore of the arbitration matter, the Singapore International Arbitration Centre between Betamax and the State Trading Corporation. Let me say here that this is dated the 5th of June 2017, and people will start to understand that when I read that particular document, the table of contents on issue 4, it is written at page 45, is the contract, the agreement Betamax had, including the arbitration agreement, illegal. That was a question that the arbitrators had to answer. Is it illegal and unenforceable? This is one of the main issues that they had to cover. So I say that today because Honourable Duval said that there's issues that were not covered. Let us say that he is wrong there. I say that respectfully, it was covered. I took it upon myself not to just come up with statements, but I went through the award to make sure that what I'm saying, I have verified it, counted, checked it, and I'm therefore convinced that what Honourable Duval is saying is not right. So let me also say that maybe if he's missed that part, I'm sure he's also missed the other part, and I say it sans hésitation. One of the lawyers who participated in this whole scandalous process, Ravindra Chetty, senior counsel. He was the one, strangely enough, representing some elements of the kitchen in those days. Anyway, Kalchul, Bartan, we call it, Bartan. So then, when I read at this particular issue at page 46, is it illegal? And I'm going to read parts of what the arbitrator said. Paragraph 170. The tribunal has found that STC has failed to discharge its burden of proving that the agreement was agreed as part of a conspiracy to commit an unlawful act under either interpretation. The tribunal has found that the PPA was not breached. I can go on, and I will. This tribunal, at paragraph 182, this tribunal rejects the submissions of the STC. Specifically, the tribunal does not find Mr. Bunjan gave evidence that was untrue in his first statement or at all. This explanation is plausible, 184, and entirely consistent with Mr. Bunjan's first witness statement. Having found that Mr. Bunjan was not untruthful as alleged by the STC. Let's pause. As alleged by the STC. Allegedly, Mr. Bunjan was lying, only to satisfy the head cooks of that kitchen. That allegation cannot provide a basis for the tribunal to draw the inference alleged. Madam Speaker, you know upon what the STC caused losses to the coffers of this country, taxpayers' money to be paid? On inferences to satisfy the head cooks of the day. And you know what is shocking? The Honourable Prime Minister referred to one of the Sufis who was helping to cook away. Then he was Minister, Honourable Badin. Wasn't he part and parcel of this whole mess? No. So it is when he was part and parcel of this whole mess, having brought an end to the agreement, It caused losses to the country. It caused losses in billions to the country. Billions. And we have the representative honorable member of the PMSD holding on to the remnants of a colonial era. The representative in Parliament and National Assembly in 2025 is still holding on to the colonial law of 1944. At least they're consistent. But then what about the honourable member of the MSM? They are holding on to this law. I'm sure they don't know why. Only because they want to satisfy the ego of the head cook. That is all.
Excellent.
No, I'm sure he's still cooking away. Huh? 8.4. And look at what I say again. 1 paragraph 195. Again, I quote, again, STC invites the tribunal to infer on the basis that government had therefore ultimately agreed to a commitment that ran counter to its earlier stipulations, that the agreement was an illegitimate transaction. However, it is more plausible that this change was simply the product of the parties' protracted commercial negotiations. The tribunal also rejects those submissions. Under the chapter of the SLO's advice, paragraph 200, the tribunal therefore finds that these allegations are incapable of grounding any inference that there was a criminal conspiracy between Mr. Bunjan and members of the then government. So, when I read all this, paragraph 207, in any event, these difficulties could not support an inference of criminal conspiracy. And I read paragraph 211D. STC led no evidence, and for members out here to listen and members of the public to hear, STC, fomenté par le gouvernement du jour, poussé par le leader du Reform Party, qui était lui-même chef de la cuisine. STC led no evidence from any person who could have given direct evidence of a conspiracy. Therefore, based upon what are members of this opposition telling us, let us hold on to the laws of the colonial days? Let us not change the law, let us simply amend it. Amend what? Amend what? Amend this way of trying to run the affairs of the country based on simple inferences, allegations that could not even be substantiated, Madam Speaker. And the taxpayers ont dû payer plus que 6 milliards de roupies. Qui alors va rembourser ça aux taxpayers? Today we are in difficulty. And they dare come and tell us we should pay up, pay out, and keep on our promises. Today we are having those difficulties because of such mess that has driven this country to the ground. And then let me look at this, paragraph E. On a related point, I quote, in its closing submissions, STC listed a number of people, who it submits have been subject of criminal or provisional criminal charges for their roles in the allocation and eventual signing of the agreement. STC did not, however, offer any public specific allegations as to what those roles might have been and when and how the conspiracy was alleged to have been entered into. So back in the day, you do not manage to have any witness, any evidence, no substantiated allegations. So shouldn't the MSM be condemned for this disaster? Oh no! They stand here at the decorum of the National Assembly. Madam Speaker, let us not change the law. Let's leave it the same. To answer to Honorable Juval that talked about, allegedly, he thinks that the Prime Minister will decide one day he wakes up, okay, I want an inquiry. This is not how it works, I'm sorry. Read section 61 of the Constitution, because you know, you can, maybe, you see, the Honorable Prime Minister is right. He is, and I understand, you know, I mean, obviously, you know, when you rub shoulders with people who behave in such a manner. Quand on fréquente lycée, on gagne pisse. You know? So when you, put it in English, when you go close to those dogs who have fleas, you start itching, you know? And this is what happens. But what I humbly suggest the Honorable Juval to do, before rubbing shoulders with dog-infested fleas, what you should do is come and take some sort of medication to get rid of the fleas. You know what is the best medication? The Constitution of Mauritius. You know what the Constitution says? There is a chapter called Cabinet, if my young member is not aware. Section 61(2). The functions of the Cabinet shall be to advise the President in the government of Mauritius. And, don't stop there. You're already drawing conclusions. Hold on, hold your horses. Get away from the dog with fleas. Hold on. And the Cabinet shall be collectively responsible to the Assembly. And I go on. For any advice given to the President by or under the general authority of the Cabinet, and for all things done or under the authority of any minister in execution of his office. So let us not forget, whatever the Prime Minister will be lawfully entitled to do, the Cabinet will be collectively responsible for it, because the Constitution says he is doing so under the authority of his power. This is how Cabinet works. Back in the day, there was a so-called Prime Minister who did not believe in this type of democracy. That is why I know he's very ill at ease right now, sitting next to the MSM. I know, when I look at some of his questions, when I try to understand how he tries to demarcate himself. Don't be afraid. Embrace the truth. This is what I say. We cannot keep on sticking to the old days of 1944. Let us evolve. Young men, let us move forward. We have promised change. This is change, Madam Speaker, and change there is. We have to adopt our changes, and what he should do is at least congratulate. He tried to do it timidly. But please, Section 61 explains all. I shall not say more. Let me say that once again I commend the bill to the House.
I need someone to second this bill. Yes. Thank you. The question is that the public inquiries. All right, I'll start again. The question is that the Public Inquiries Bill, number 5 of 2025, be read a second time. Those in favour say aye. Aye. Those against say no. The ayes have it.
Public Bills Committee stage.
Yes.
Clause 1, short title. Clause 2, interpretation. Clause 3, setting up of Board of Inquiry. Clause 4, terms of reference of Board of Inquiry. Clause 5, no determination of civil or criminal liability. Clause 6, duty to inform Assembly. Clause 7, suspension of inquiry. Clause 8, composition of Board of Inquiry. Clause 9, term of office of members. Clause 10, secretary to Board of Inquiry.
The question is that clauses 1 to 10 stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 11, technical advisors and experts. Clause 12, rules of proceedings. Clause 13, public access to proceedings. Clause 14, restrictions on public access. Clause 15, law of evidence to apply. Clause 16, appearance of law practitioner. Clause 17, powers of examination. Clause 18, persons likely to be prejudicially affected to be heard. Clause 19, division of opinion among members. Clause 20, submission of inquiry report.
The question is that clauses 11 to 20 stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 21, laying of inquiry report before Assembly. Clause 22, publication of inquiry report in Gazette. Clause 23, immunity from suit. Clause 24, protection of witnesses. Clause 25, remuneration and inquiry expenses. Clause 26, no cost against member. Clause 27, duties of police officers. Clause 28, offences. Clause 29, criminal proceedings. Clause 30, judicial review. Clause 31, regulations. Clause 32, repeal. Clause 33, commencement.
The question is that clauses 21 to 33 stand part of the bill. Those in favour say aye. Those against say no. The ayes have it.
The first schedule.
The question is that the first schedule stands part of the bill. Those in favour say aye. Those against say no.
The second schedule.
Question is that the second schedule stand part of the bill. Those in favour say aye. Those against say no.
The third schedule.
The ayes have it.
The third schedule.
The question is that the third schedule stands part of the bill. Those in favour say aye. Those against say no. The ayes have it.
Title and enacting clause.
Question is that the title and enacting clause stand part of the bill. Those in favour say aye. Those against say no. The ayes have it. The question is that I do report to the House that the Public Inquiries Bill number 5 of 2025 has passed the committee stage without amendment. Those in favour say aye. Aye. Those against say no. The ayes have it. I will now resume my chair. You may resume your seats. Thank you. Honourable members, I have to report to the House that the Public Inquiries Bill number 5 of 2025 has passed the committee stage without amendment.
Public bills, third reading.
Madam Speaker, I beg to move that the Public Inquiries Bill number 5 of 2025 be read a third time and passed.
The motion needs to be seconded. Yes, Honourable Dr. Boulel, yes. The question is that the Public Inquiries Bill number 5 of 2025 be read the third time and passed. Those in favour say aye. Aye. Those against say no. The ayes have it.